Hi, my name is Jennifer George, and I'm an attorney at Isaac Brandt Ledman & Teeter. One of the areas of practice that I enjoy is employment law, and in particular is advising employers in a way that makes it easy and time effective for them to do what they want to do, which is to run their business. And one of the things that I think all employers have in common is employees. And if you have an employee, they were once with you and then they're not after a period of time. And what that leads to is usually verification of employment or other employers asking for what we would commonly term references of the period of time that the employee was with you as the employer. And today's video is about how to deal with those references. And I think the first thing to point out is, in fact, such references can lead to liability on the part of you as the former employer. And that may seem strange to you. After all, you say, wait a second, I'm no longer their employer. How can they possibly want to bring a claim against me? And the way that it would come up is in the type of reference that you give for your former employee. The claim that it would probably fall under would be defamation, or maybe what would be termed tortiously interfering with their contract or their relationship with their new employer. So let's talk about it. We always hear about defamation. What is defamation? In the legal world, there would be three things that former employee would have to prove. One, that what you told their new employer was false. Two, that you in fact told it to them, or what we would say in legalese as published it to someone else. And then three, that it actually damaged them, that it caused some damage or a bad effect on their new relationship with their new employer. Now, tortiously interfering with the relationship with the new employer would mean basically you just interfered, you caused damage or affected in a bad way their new employment relationship. It's a fancy way of saying that. So when we look at those things and what an employee may be able to prove and cause liability to you as a former employer, you need to ask yourself, practically speaking, then what should I do? You should consider such things as what is going to be your standard policy on how you want to reply to such new employers' requests for references. For instance, can you have the same person handle such references so that you can ensure that they're handled properly, whether it's you personally as the chief employer / business owner, or whether it's an HR representative that you might have. Secondly, think about what we said about defamation. Remember, the first thing is that it has to be false. When you share references, consider, are you sharing opinions? Can what you're sharing, can it be verified by, for lack of a better term, since we're talking legal, evidence? Can you point to a certain document that can prove what you're saying so that if down the pike we're looking at a possible claim, there's no question that it's not true? As I said, it's a nature of the business to deal with references of prior employees. And while you want to be helpful and that you want to give the most information that you can, you need to be mindful that such requests for references can lead to liability for you as a former employer down the line. As I said, at Isaac Brandt Ledman & Teeter, employment law is only one of the areas of law that we practice and that we enjoy very much. If you have any questions about this or anything else that we can help you with, we are available on the web at isaacbrandt.com, or we can be reached at 614-221-2121. Thank you.